Let's get day 2 started of VBS Live, the world's first tokenized event. Yesterday we had just so many awesome speakers and panels, and I'd like to thank everyone that made this event possible. So today, unfortunately, Cal cannot join us. We just got informed that there are protesters in LA in front of his office building, so we will be 3 speakers here and myself. I'd like to introduce Diana Stetiu from FinTech Law Office. She will cover things in Europe, the jurisdictions, the legislation. And then we have Kiana Shek from DigiFinex. She will cover the jurisdiction of Singapore. And lastly, we have Yanina Petrovskaya from RPL Lawyers. Yanina is from Liechtenstein, and she will cover Switzerland, Liechtenstein, and maybe some other jurisdictions Cal cannot, unfortunately, tell us about. So, yeah, let's get it started, guys. I think we should just jump right in with the differences between the jurisdictions you guys cover. Maybe Yanina can start.
Great, Matthias. Thanks a lot for organizing this fantastic online event. Thanks a lot to all of you guys for joining. And I would like to start, since we announced that the topic will be mainly STO, and then if we manage to cover some of the things for crypto exchanges, we do so. My first question, or rather a topic to discuss with the audience, would be if you conduct a security token offering, how you choose a country or a jurisdiction where to do it. We have already prepared some sort of checklist or sort of algorithm how to choose a country. And in my experience, in our experience, it is really important to start with your investors and your clients, where they are located. Because a lot of crypto projects, they choose a country to do their project in just by saying, oh, we've heard Switzerland is crypto friendly, or we've heard Estonia is crypto friendly, or we do it on Cayman Islands, without really considering a lot of factors which are important. And a major factor for security token offering is that security token normally is considered to be financial instruments in most of the jurisdictions, which means that the national regulator, it is really up to the national regulator to have rules in place which regulate how you issue a security token, on traditional securities or new securities, but in any way it is considered in most of the cases financial instrument. There is another question a lot of projects ask us: can we just issue security token in one country and distribute it all over the world? No, guys, unfortunately. It would be nice to have, maybe, but the world for now doesn't function this way. And the regulations for now do not function this way. Normally, you have to have to issue your security tokens, your tokenized financial instruments in the country or in the market where your investors are. And that's why I would like to give brief introduction maybe on the US, though I'm not a US lawyer, and this is not any sort of legal advice or solicitation, no way. LP lawyers, we're based in Liechtenstein. We do some of the projects both in Switzerland and in Liechtenstein. And we have seen projects which target investors, for example, both in Switzerland, let's say, and in US. In Switzerland, most likely, you would need to register a prospectus, while from the beginning of 2020, they have changed the regulations. And it means, and for now, you need to register a prospectus. Before 2020, you didn't have to. Another important thing regarding to Switzerland is that they've introduced a fantastic DLT securities draft law, And I believe that Switzerland, FINMA, Federal Council have done really great job to develop the regulatory framework in general for all types of crypto projects, and especially for security tokens, to allow a lot of assets, traditional securities, and some other illiquid objects like real estate, collectible cars, art, etc., to be tokenized. And I've been working for at least a couple of years. Federal Council prepared a great report for any sort of crypto projects, which I really advise people to read before they do it in Switzerland. And the DLT law gives actually the a really great framework for security tokens to be issued first and then to be transferred on the secondary market on the blockchain. This is actually the main thing which you have to know. And if you, for example, we have seen projects which have done some of the security token offerings in Switzerland, and then they do it in the US. Again, since Cal is missing, I have to sort of cover briefly his part.
Yeah.
In the US, you mostly do it on the Reg D. You prepare the documents, you do not really file them. You go under the exemptions and you use the Reg D, which mostly is only for accredited investors. So you have to keep it in mind, but for a lot of hedge funds, institutional larger investors, it is not a problem. And we have seen that US, let's say institutional larger investors, that they invest in security token offerings. Of course, if these are quality projects, they conduct their own due diligence. Yeah, maybe we could switch now to Singapore, and then I could also give us feedback about Europe. It would be nice if Kiana and Diana, you could briefly introduce yourself, your firm, was just a couple of sentences, and give us short feedback what the projects have to take into account if they do an STO from Singapore and from Europe, from which countries you have experience with. Kiana, shall we start with you? Asia, Singapore.
Yeah. Sure. So first of all, thank you for inviting and thank you for the opening. I'm the co-founder of DigiFinex. So we are the global top exchanges for digital access. Our headquarters is in Singapore, but we also have offices in Hong Kong, China, South Korea, Malaysia, Australia. So basically, we are trying to figure out how to fulfill all different jurisdictions around the world, starting from Asia. And where and how can we satisfy the blockchain projects who want to do SEO? Because it's the security tokens, it has a higher level of entry to the blockchain market. Especially we are listing different sort of tokens through ICO and IEO on our platforms. But then security tokens are basically, and well, from the perspective of user and exchange, they're investment where we provide a marketplace for trading. And then it's very popular because it's sort of like a fundraising in the cryptocurrency market. Like the public market doing the IPO is the same purpose, but then we switch it to the blockchain industry. So I would say, first of all, the needs of security tokens is to embody a very good investment. The product should be good enough. And secondly, a very outstanding marketing strategy to expand the reach of these products, because even though until now, after these few years, blockchain is still it's just the beginning. We're still to educate the public. It's a long way to go. So currently, we say even though we are trying to fulfill different jurisdictions, let's be specific to Singapore. We are very, very close, I think, getting the license in Singapore. But still, security is not for securities. It's still just the exchange, for our exchange. For the STO, that is a highly risky product. We have to be very responsible and careful for our customers' assets. So the guidelines from different countries are still blurred. The governments have limited experience in setting the rules and regulations. Even though there are drafts in Hong Kong previously, we still are very careful to move forward. You have to be very cautious, especially for all these new projects, blockchain projects, or traditional industry trying to do tokenization as an STO. There's a lot of DD work to do, more than we could imagine. So I'd say it's still a long way to go. It's not gonna happen or taking up this year.
Yeah, so if I may ask you, are they drafting new laws in Singapore to fulfill, let's say, those needs of the blockchain projects, or are they under the, let's say, Banking Act, which you have there, or how does it work?
I think they have a new committee from the licensing to the SEO, how to even define the project, define the token. And somehow we can tell that from the committee's comments, there will be area is not just purely utility token or security token. We still have some gray area in between. So the definition, we need the consensus.
Yeah.
So I'd say we need the big, but even the banking industry, they don't have enough experience for that. So I think no single government can work it out by themselves. We need the consensus built with the governments.
Yeah, makes sense. Thank you. Kiana?
Yeah, so I'm so happy to be today with you guys. Thank you for having me here. I am a Romanian law qualified lawyer with more than 8-year experience advising banks, payment institutions, asset management companies, private equity funds, and I have a particular interest in and focus on open source projects and DLT technologies. So I had the opportunity to advise entrepreneurs on various aspects related to blockchain-based solutions. Regarding the European Union jurisdiction that I will cover today, I will start by saying that currently there is no harmonized legislation on crypto assets at the European Union level. What we have to date is a patchwork of national rules on certain aspects related to crypto assets. And when crypto assets fell within the existing legislative framework of the European Union, of course, the existing regulation will be applied. So this reality is subject to the European Commission, and in December last year, a consultation paper was published. So it is expected that, let's say, in the third quarter of 2020, some new framework provisions, some framework on markets for crypto assets will be issued. So with respect to security tokens, there is no definition at the EU level. I mean, the EU financial services legislation in place. However, when security tokens meet the condition to be a specific type of a financial instrument, they will be regulated as such. Whether or not a crypto asset is considered a financial instrument is to be determined by each individual national competent authority of each member state. So although this determination is based on what the MiFID II says about financial instruments, this is the directive in financial instruments applicable today at the European level. we have seen that member states have taken different approaches as to what is a financial instrument when we talk about crypto assets. So the approaches are different, and it will be helpful to have more clarity. However, considering that a security token would qualify as a financial instrument and as a transferable security, there will be a whole range of legal provisions that would apply, like MiFID II, regulation on market abuse, prospectus regulation, and given that the security token would be a financial instrument covered by MiFID II, they would also be subject to CSDR, meaning the regulation on improving securities settlement in the European Union and on central securities depositories, and also EMIR regulation on OTC derivatives, central counterparties, and trade repositories. So in practice, although we have these extensive pieces of legislation, there are many open challenges and many gaps. For example, there is lack of clarity around the services that may be considered asset services, custodian services, safekeeping within a DLT environment. Also, in terms of settlement, there is lack of clarity on what could constitute delivery versus payment, DVP, in a blockchain or other type of DLT network. And it would be very helpful to have clarity whether requirements for DVP can be satisfied through the delivery of a crypto asset, provided that the other requirements of the DVP definition are met, considering that the fiat cash leg is not processed in the network. Although there are platforms on which for example, one crypto asset is exchanged for another where both legs may be on chain. And as you know, some platforms have incorporated the use of smart contracts, which enable actually automatic DVP or some similar arrangement. So these aspects need to be considered more at the European Union level legislative process, because at this point in time, the security token chain life is not very clear how an investor or even an institutional investor could fit in. So this is my approach.
Thank you very much.
If I may add a couple of words, absolutely. Thanks you a lot, Kiana and Diana, for giving this, overview on what is going on in Asia and what is going on in Europe. I totally agree with you that it is actually more or less a patchwork of national regulations or fragmented regulations, and we when we're talking broadly, we talk actually about fragmented regulation and legal uncertainty in a lot of points which refer to security tokens. And this is all also because the market of security tokens is in a very early stage. Yeah. And we have all of us, the lawyers, the exchanges, the regulators, the governments. For all of us, it is a lot of learning by doing. And just to mention an example of Liechtenstein, because they've already gone through the regulatory work. They've been working for 3 years on the Liechtenstein Blockchain Act, which should be, I would say, quite a unique basis for assets tokenization. Yes, they use sort of national legislation, civil legislation for what token is, how you transfer a token, how you do a registry of security tokens on blockchain. But on the other hand, of course, if a token qualifies as a financial instrument, then all of the European regulations
Yeah.
are applied. And most likely, if you would like to have your prospectus for security tokens passportable on the European market, you would need to register a prospectus with the regulator. And around, if I'm not mistaken, over 15 STOs in Switzerland and around 7 in Liechtenstein. So just the number shows us that on the one hand, it is interesting, both for projects and investors, but on the other hand, also there is a lot of work to do in regards to regulation and how it is applied in real life and how it should work. Also because of the lack of secondary markets, the secondary trading platforms in the EU, that is a major issue. Kiana has also brought this up, that having just a crypto exchange for cryptocurrency is one thing, but having an MTF for security tokens is a way more difficult thing. And there is, I think, one platform that has got a license, but they're not operational yet in Liechtenstein, and I haven't heard about many others in Europe which are right now in the process of getting their license. And if I got you, Kiana, right, you are in the process right now of getting the license for trading of security tokens in Singapore. Is that correct? Yeah,
Yes.
but it takes not months. I would say it takes years to get all this done from the technological and regulator perspective. So yeah, really, it's just, on the one hand, it is a very interesting market, but on the other hand, it is a lot of work to be done, and a lot of projects really, especially from crypto area. I think that they underestimate the amount of regulatory work that they have to do before they can launch a security token, or especially before they can obtain a license for trading in security tokens.
Yeah,
Right.
I think, sorry,
Exactly.
I think a lot of projects jumped, let's say, exchanges from the ICO hype, tried to jump to STOs quickly, and then realized it's not that easy because the legislation hasn't been passed. You don't know what to do. You need to hire more compliance. It's very cost intensive. So you go from making a lot of money, let's say in the ICO hype, to 3 or 4 years of building something new on a maybe framework that doesn't work for this kind of tokens. So you basically have to build a whole new company.
Exactly. I think a lot of discussions around STO is just too early. It's far from that. We have to first educate the public about not even ICO, about blockchain, about cryptocurrency first, and that already takes years. So that's why I say it's really important that exchanges and all the players in the market, we need to have a long-term vision. It's not just a short-term revenue idea or business. We have to be sustainable. Like to us, we've been operating for 3 years, but we can see a lot of exchanges, they open up so quickly and then they shut down the business so soon, whichever there's a bearish market, which is really bad for the market and also for the industry and also for the investors. They are scaring all these traditional investors away. So that's why I think sustainability should be the first concern for all the players in the blockchain industry.
Absolutely, couldn't agree with you more. Matthias,
I think we are basically at the end. I see we have maybe one more minute left.
That's what I thought. Guys, I really enjoyed this. On the one hand, really in-depth discussion, but on the one hand, also an overview for a lot of projects which would like to do an STO all over the world, US, Europe, Asia. And I also really think that our task is, and that's what we do now also, to educate people and to work in a sustainable way from the very early stage where we are right now, and to bring it during the next year to maybe a more developed stage. And it would be great to maybe talk in a couple of years and see how the market has developed further.
Yeah,
Definitely.
let's revisit this topic on VBS 10 or something.
Absolutely,
So
absolutely.
thank you guys for joining. It was a pleasure.
Thank you.
Covered
Thank you.
everything, and I thank you so much.
Thanks a
Bye
lot.
bye.
Thanks.
Thanks. Have
Bye.
a great day. Bye bye.
Bye-bye.